Hello and welcome to today's program titled Legislative Update, Recent Developments Impacting Washington State Employers. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining a CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for a CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you received recently. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I'd like to turn over to our first speaker. Lauren, you may begin.
Good afternoon, everyone, and thank you for joining us. We are really excited to have you with us for this timely and important discussion. My name is Lauren Paris-Watson. I'm a partner here in our Seattle office, and I'll be kicking off things today as we dive into today's program. I just want to introduce the speakers. We're fortunate to be joined by a really excellent panel of speakers, including Emma Kazarayan, who is an employment counseling and litigation partner, and Dan Kulikover, who's an employment litigation senior associate. I'm also thrilled to introduce the newest member of our team, who's my partner, Kyle Nelson, and is joining us officially today. It's the very first day with Seyfarth. He brings a wealth of knowledge in wage and hour issues and class actions, and we're excited to have him on board. Before we begin, I just want to highlight a resource we released earlier today. It's our very first edition of the Washington Peculiarities. It's there on the screen. And this is a report that deep dives into some unique legal and regulatory nuances that impact your businesses and all businesses that are operating in Washington State. It's a valuable tool. We've worked really hard, we're really excited about it, and it will help you navigate the complexities of the local landscape. You will receive a copy following today's session. We encourage you to reach out with any questions that you have and any feedback that you might have after you've read through it. With that, I will turn it to Kyle to get us started. Thank you.
Next slide. Today we're going to focus on 12 bills related to labor and employment law. There's been quite a bit of developments in Washington. And let's go to the next slide. We'll start off with one of the most important bills from the wage and hour perspective, which are amendments to the Washington Equal Pay and Opportunities Act. Now, as some background, as many of you probably know, in 2023, Washington amended the Equal Pay and Opportunities Act to require employers to post the salary ranges and benefits information in their job postings. But there were a couple factors which led to a problem. It was a poorly drafted law. There were opportunistic plaintiffs firms, and there was difficulty complying 100% of the time. In fact, just a handful of firms, frankly, just one firm filed most of these cases. We're filing over 200 class actions. They would search out not deficient job postings and file a class action alleging $5,000 in damages per applicant. Now, this created a problem because there was a lot of employers who made honest mistakes, and there was just a lot of difficulties complying with the law. It was rare that there was actually some bipartisan movement in the legislature this session to get a fix to the Equal Pay and Opportunities Act to rein in some of the class action litigation and make it more of a manageable bill. What ended up being was a negotiated resolution, which is a little bit of a Frankenstein approach, but depending on your perspective and the position of your employer, you might find it to be a welcome fix. Next slide. There are two major changes to the Equal Pay and Opportunities Act. No longer is just simply having a deficient job posting itself a violation. There first has to be a notice by the applicant or someone on behalf of the applicant, giving the employer an opportunity to cure the mistake. But when I say it was a Frankenstein approach, they had to settle on a 5-day cure period, which for many employers is not going to be a lot of time to move quickly. And the law also doesn't state who the applicant or an attorney or someone on behalf of the applicant has to give notice to. So there may be the case where they give it to a low-level manager or serve it on the registered agent or otherwise try to give the notice in a way that it helps them make you slow to act. So that'll be an issue that'll be litigated, but there's only 5 days to cure. So once the notice is given, employers will have to move quickly. But if the employer does cure their posting, there can be no damages assessed against the employer. So it does give you an opportunity to correct honest mistakes. Another part of that negotiated resolution was that the cure period is only in effect until 2027, mid-July 2027, at which point it'll sunset. Now, maybe it'll get extended, maybe it won't, but I think this is supposed to be an education period for employers to work on their practices to make sure things don't fall through the cracks. The second big change, and this will have some effect potentially on those with pending litigation right now, is that statutory damages are no longer just $5,000 per violation per applicant. They are now a sliding scale between $100 and $5,000. That's a huge change for those with pending litigation, but there is some question whether that sliding scale damages is going to be applied retroactively. My biased opinion is that it will be, but it is an open question for the courts to make that decision. The court can look at several factors to decide whether to award between $100 and $5,000 per violation. They're going to look at things like you'd expect, like whether it was willful or repeat violation. They're going to look at the size of the employer, and then they're going to look at whether they can deter future noncompliance through the size of the award. There's also a catch-all at the end, and that the court can look at other factors. So frankly, any good argument the employer has can help drive the damages down from $5,000 if there was a mistake made. Next slide. There are two other changes that are significant, maybe a little bit less so than the major ones I described. The first is that in the prior law, it said that you had to post a range. And that created a problem for employers who had a CBA, which mandated a single rate of pay, or an employer who was just going to provide the minimum wage no matter what. The Washington Department of Labor and Industries took the position that even if you're only going to put a set rate of pay, you have to list a range in your posting. So if you're only going to offer $20 an hour, your range would say $20 to $20 an hour, which is really confusing for applicants, and it just didn't make sense. So they fixed that in this new version of the EPOA, and now employers can now put a fixed rate of pay if there is no range available for the position. Another change is that employers are no longer liable if a third-party website scrapes the data from somewhere without their consent. And this was a big issue in the prior law, where third-party websites would pull it off of your careers page for your employer page, and maybe you would mistakenly scrape the information or would not include the pay range, even though the employer's posting did have the pay range. So that'll fix that issue. Governor Ferguson hasn't signed the bill yet. But don't have any indication how he will, what decision he's going to make on that. But unless vetoed, it'll go into effect in July of 2025. Next slide. There was another amendment to the EPOA. This one was a little bit more straightforward. It amends the EPOA to say that you can't require a driver's license as a condition of employment, and employers can't prohibit statements in a job posting to say that a driver's license is a condition of employment. Now, there's a giant exception to this. Employers can require a driver's license as a condition of employment if it's related to essential job function or serves a legitimate business purpose. Now, they didn't define legitimate business purpose in the bill, but LNI is authorized to adopt rules for the chapter, and that would probably be, if they do adopt rules, that would be a good place for them to define that term further. There's no private right of action like in the other portion of the EPOA I was just describing. So enforcement is just through an LNI administrative action, and LNI can award statutory damages or actual damages up to $5,000. Next slide. There was Senate Bill 5104, which is about employers deterring protected activity by threatening an employee regarding their immigration status. Now, the law is, it's kind of hard to understand, but what it really boils down to it is that employers can't make threats about immigration status to deter protected activity. It's a little bit like an FMLA interference claim. The employer can interfere with an employee's exercising their rights by threatening anything about their immigration status or their family's immigration status. This is similar to the prior bill where enforcement's through LNI, and LNI can award statutory civil fines, or actual damages or civil fines. The civil fines are a stepped scale, which you will often see with an LNI enforcement scheme. $1,000 for the first violation, $5,000 for the second, and $10,000 for violations thereafter. Next slide. This is another very big change to Washington law. Under the Fair Chance Act, which you might have heard called the Ban the Box Act, employers could collect criminal history information of an applicant once they decided they were otherwise qualified. The job posting under the prior act couldn't categorically exclude applicants with criminal history, but once they determined an applicant was qualified and they gathered information through a background check or some type of questionnaire to the employee about their criminal history, they could make a job decision based on their criminal history without justifying it. But in a big change, Washington now requires employers to wait longer to collect that information, and then if they make a decision based on information, they have to give the applicant time to provide information about that criminal history, and then when the employer acts on the criminal history by denying the applicant a position, they have to provide a written notice of the reasons that they made the decision. Next slide. Employers can only act on a criminal history of an applicant once they have a legitimate business reason. This act defines legitimate business reason, and the first is whether the conviction will have a negative impact on the applicant's ability to do their job. And the second, the second will probably be where most employers will hang their hat, is that the conviction will have some type of harm to their business or property or their business assets. So the factors that the employer can look at are the seriousness of the conduct, how many convictions the person have, the duties of the job they'll be asked to do, the place the job is performed. I think that's getting at whether it's going to be around vulnerable people, and then rehabilitation and work education since the infraction. And like I said earlier, this is going to be where it's going to be a little bit of an administrative hassle for employers. If they are going to make a decision based on criminal history, they have to provide the applicant 2 days to correct or explain their record. And then if the employer acts on that criminal record by denying the applicant the position, they have to provide a written decision, including its reasoning and assessment of the factors I described above, which are the seriousness of the conduct, convictions, and such. Next slide. Federal contractors are exempt. This is enforced by the Attorney General's office as an administrative action or a lawsuit. So this has more teeth than the LNI actions because the Attorney General's office has specialized tools such as civil investigative demands and just in the way they can staff their cases that can be really hard for employers to fight against. And so the Attorney General's office can seek money violations, but they can also pursue unpaid wages. It wasn't defined in the statute, but I assume what that is getting at is if an applicant is denied a position, the Attorney General's office can pursue unpaid wages as if the applicant had worked through the pendency of the lawsuit. This has been signed into law. It goes into effect in about a year for employers greater than 15 employees, and then on January 1st, 2027, it applies to all employers. Next slide. In 2023, Washington enacted specialized meal and rest break rules for hospitals. And those are hospitals that are licensed as a hospital under a specific RCW. And so this may not apply to all the people on this webinar, but there are some lessons that can be learned just in how things are trending on meal and rest break compliance and waivers. But so the prior law changed the way healthcare could do their meal and rest breaks. And it did a couple of things. It did 3 primary things. One, it required scheduled rest periods. It required that meal and rest breaks be uninterrupted. For all of the employers, there are circumstances you can interrupt meal and rest breaks if you give a new meal break or you return the employee to the rest break until they get 10 total minutes. And the third thing is employers have to keep records and report to LNI how many breaks were permitted and how many were actually missed out of the ones that should have been permitted. And it also allows hospital workers to combine meal and rest periods. Next slide. Now they added on to these 2023 changes recently, and under the new amendments, I'm not going to go through line by line, but the general gist of it is that it changes which meal periods can be waived and when they can be waived. It says that employers can definitely waive the first meal period, or the employee can waive the first meal period if the shift is less than 8 hours. But it also changes and says that the second and third meal period can only be waived if the employee takes at least one compliant meal period. So it takes away the ability to waive all meal periods. But it also clarifies that employees don't have to waive the meal period entirely. They can just waive the timing of it. So if the employee does not want it within the first 5 hours, which would be normally required, if the employee still wants their meal period, but they want to take it 6 hours into their 10-hour shift, that's something they can do if an appropriate waiver is signed. Next slide. And I think this is where showing where the trend on meal break waivers is going. This new amendment specifies how waivers can be entered. Right now, waivers can be oral for most employers. They don't necessarily need to be in writing, although it is best practice. But this law sets out a couple things about the waiver. It must be in writing or electronic. It must be retrievable by the employee upon request. It must be prospective. I mean, you can't waive your meal break after you've already missed it. So it has to be something that's on file before the meal period that you're going to waive. There's some language about whether it has to be on an agreed form if there is a labor union. The waiver must include a summary of the law about meal and rest periods. That goes to whether the waiver be knowing and voluntary, and many waivers already do include that. It must advise employees they have rights under the CBA, and it must advise the employee that the waiver is voluntary. Now, the last major thing about meal and rest breaks under these new amendments is that employers must now report the number of waived breaks to LNI. Previously, they just had to report how many should be allowed under the schedule, and then how many are missed. So now the third thing is they have to report the amount of waived breaks to LNI. Next slide. I think I'm running a little short on time, so I'm going to skip this slide because it just goes over the penalties, and I'll pass it over.
Hi, good afternoon, everyone. Thank you for being here. I'm going to talk about a few leave and accommodation related changes that either have already become law or are likely soon to be, beginning with HB 1213, which is an expansion of Washington paid family medical leave. So unless the governor vetoes the bill, it will become law tomorrow and is due to go into effect this upcoming January. And one of the most critical changes is going to be a pretty significant expansion of employment protection obligations. So employees taking leave are going to now, when assuming the law goes into effect, are going to become eligible for employment protection after just 180 days of employment. So that's approximately 6 months. And what it currently is that they have to work at least 1,250 hours in the 12 months immediately preceding their leave to qualify for protection. So just for reference, an employee that's working 40 hours per week would need to work close to 8 months to hit that threshold. And that, of course, would be without holidays, sick days, PTO, et cetera. So if the change goes into effect, there'll no longer be that hours threshold, which means that even folks that work very few hours, that work part-time, they're going to be eligible for employment protection. Also, generally, employees are going to become eligible for employment protection a bit sooner than they otherwise would if you're looking or kind of counting from the start of their employment. And also, this is probably the biggest one, they don't need to requalify right? Once they hit that 180-day mark from the start of employment, they're eligible. So this is going to be a pretty impactful expansion, again, assuming the governor doesn't come in with a veto today or tomorrow. So another way that employment protection is being expanded is that employers with fewer than 50 employees will now also have employment protection obligations. So the way that it works, it's a bit of a kind of phased approach. So this coming January, the employment protection obligations would expand to all employers with 25 or more employees. The following year, it would be employers with 15 or more employees. And then the year after that, in 2028, it would be employers with 8 or more employees. So definitely quite a bit of an impact on that front as well. The change also reduces the minimum leave duration to 4 hours. It currently is 8. And I think, again, this kind of just goes with that theme of we see the legislature wanting to expand access to paid family and medical leave to folks that are on part-time or maybe reduced hour arrangements. It also expands the grant program for small businesses. So essentially just making provision for businesses with fewer than 50 employees to be able to apply for grants if they need to hire temporary workers to kind of absorb that time that they're now on the hook for job protection. I think that probably doesn't apply to most of the folks on this call, and it's kind of an involved process. So if anybody has questions about it, please feel welcome to reach out and we'd be happy to help. I also have on this slide that the change would expand the notice requirements, and that's true. It kind of just changes what needs to be on the LNI poster. So I think we can expect that LNI may be publishing a revised poster that just has some additional categories of information on it. And then there's also a pretty involved notice requirement with regard to the job protection piece and kind of what's counting and when the employee is due back at work. But again, it's really kind of multi-layered, and so beyond the scope of this legislative update because we have a ton to cover, but please do feel welcome to reach out if you have any questions about that, and we'd be happy to talk you through it. Next slide, please. So up next is SB 5217, which is a recodification and expansion of the Healthy Starts Act, which makes provision for pregnancy-related accommodations. And this is another one that will become law tomorrow unless Governor Ferguson vetoes it. But we have a bit of a longer runway before it would become effective. So it wouldn't be this coming January, but the following January, 2027, which is unbelievable. So just as a reminder, the Healthy Starts Act, which I believe went into effect 2017, requires Washington employers to provide certain pregnancy and post-pregnancy accommodations, things like more frequent restroom breaks, or modifying no food or drink policy, providing seating for jobs that where the employee is generally doing it standing up, and then also providing breaks and a space for expression of breast milk for up to 2 years postpartum. And it used to be that the law, the Healthy Starts Act, applied to employers with 15 or more employees. With the change, it would be all employers. So if you have even one employee, you're in. And I'm kind of burying the lead here because really the biggest change is that any time that's spent with the law, if the law goes into effect, any time spent expressing breast milk or traveling to like the designated pump room, it is paid time under this new change. So it's paid at the employee's regular rate of pay, and the bill actually specifies that the pumping time is in addition to meal and rest breaks that employees are entitled to under Washington law. So that's a pretty seismic shift, and something that for those folks on the line who have facilities or workplaces where which are quite spread out, and maybe there's a pumping room that's like a 15-minute walk from where an employee is actually working or where their desk or cubicle is. That's the sort of thing where we need to be probably thinking about this, even though we have a longer runway on this law if it becomes effective, but definitely something to start thinking about and factoring in that it's that's time that's going to need to be paid going forward if the law goes into effect. Next slide, please. Okay, next one on our list is HB 1875. This one has been signed into law and it'll become effective this coming July 2025. So in a little over 2 months, actually, because it's later in July. But with this change, employees can now use their accrued paid sick and safe leave to prepare for or participate in immigration proceedings involving themselves or a family member. And there's just, that pretty much sums it up. Like, there isn't a ton to say about this one, except, I will say the wording of the law is pretty broad and permissive. So it says any judicial or administrative immigration proceeding. And in terms of the documentation that an employer can require, again, it's, as is the case under the existing paid sick and safe leave framework, the documentation can only be required if it's an absence that's 3 or more consecutive workdays. And even if it is an absence that's 3 or more consecutive workdays, an employee can just provide their own written statement that says they're using paid sick and safe leave for this purpose, and that's sufficient. That's sufficient documentation under the law. So, the documentation doesn't need to identify, hey, this is the family member who, kind of the identity of the family member whose immigration proceeding it is. It doesn't need to identify, the cause number, anything like that. It can really just be that simple and straightforward. So this is, again, kind of an expansion, pretty significant, just in terms of being mindful of like what sort of documentation we can require, and again, just kind of broadening the scope of what paid sick and safe leave can be used for. But it doesn't change the accrual rates or anything like that under the state framework. Next slide, please. Okay, and last one on my list before I hand it over to Dan is SB 101, which expands access to leave and safety accommodations for victims of hate crimes. And this, again, due to become law today, unless the governor vetoes. I checked about an hour ago and still no veto. So this is, due to go into effect this coming January. And this law is expanding the leave and safety accommodation provisions that already exist under the Domestic Violence Leave Act. And so in addition to the Domestic Violence Leave Act extends these leave and accommodation provisions for, victims of domestic violence and stalking, a couple other categories there. So now it will also extend to victims of hate crimes. And in this law, the hate crime has actually a very specific definition. It incorporates by reference a definition that's in a criminal statute. And a hate crime in that statute is defined generally the commission or alleged or attempted commission of an act or threat of violence, an assault or property damage that's based on a protected characteristic. And there are itemized protected characteristics there, covers, sort of the categories you might expect, race, religion, sexual orientation, sex, sex expression, color. It's not quite as lengthy of a list as like the Washington Law Against Discrimination. But again, like I said, covers probably most of the categories you would expect, at least kind of the big banners. The other thing that is interesting about that law that kind of sets out the definition for hate crime is there are certain categories of acts that have an inference of being a hate crime. So and it's itemized, and I've included a couple of salient examples here. So one example is burning a cross on the property of a person that the perpetrator believes to be of African American heritage, defacing the property of a person that the perpetrator believes to be of Jewish heritage, defacing it with a Nazi symbol. So this is something where being familiar kind of with the what the definition is of hate crime in that statute that's incorporated here, I think is important. Because we've seen certainly incidents, kind of workplace violence type incidents, or where things like this are happening. And so really important to be cognizant of what triggers the protections under the act. because as you may recall, under the Washington Domestic Violence Leave Act, the sorts of accommodations and leaves that are anticipated include things like changing an employee's phone number, changing their work location, right? Things that are intended to sort of insulate them or protect them from, either the domestic violence or in this case, the hate crime or hateful conduct that they've experienced or allegedly experienced. But please, with any of these, do feel welcome to reach out if you have any questions. I believe you'll all be getting a copy of the slides, but we're happy to answer any questions. And with that, I'll hand it off to Dan.
Thank you, Emma. So I think I'm rounding out the presentation today. I've got 3 bills that are a bit of a smorgasbord of different topics. So the first is, if you can go to the next slide, please. The first is Securing Timely Notification and Benefits for Laid Off Employees Act, which is a real mouthful, but it's essentially the mini WARN Act for Washington. So it's a little bit broader than the WARN Act, and it is going to be going into effect pretty soon. Next slide, please. So the WARN Act applies to employers with 100 employees. The mini WARN Act here in Washington will apply to employers with 50 or more employees. Similar to the federal version, notice has to be given in Washington. It'll have to be given to the Employment Security Department with some specific pieces of information. One caveat that is important to note is that employees who are out on paid family or medical leave cannot be included in the mass layoff. So that's something to be sure that you're tracking as an employer if you have to go through with one of these. There are some exceptions to when a WARN Act notice is required under this new statute. They're listed there, but they're pretty common sense ones. If you're seeking capital or if there's a natural disaster or some other unforeseen circumstances. If you could please go to the next slide. This is a quote from the statute that I wanted to highlight, which is pretty strong language, which says that if there's a failure to provide proper notice, then penalties then employers are liable to each aggrieved employee, and the word is there, which makes it a little more forceful, obviously. The penalties in this statute include both back pay and lost benefits. So that's something that you want to be tracking. If you have a mass layoff, you want to make sure that you don't have to come up with numbers on the fly for how much these back pay and lost benefits would be. So if there's people who are out, you need to make sure you're tracking that appropriately. And it creates a private right of action here and a fee shifting provision, which obviously can make resolving these kind of cases more difficult if one is brought against you. Can you please move on to the next slide? Okay, the next bill is Senate Bill 5041. As with the bills that Emma was describing, this bill should go into law today unless the governor vetoes it. The effective date for this bill will be January 1, 2026. This bill will give unemployment insurance to striking workers. It's not the first in the country. That distinction goes to New York and New Jersey, but it is joining a short list of other states. There are some requirements that striking workers would have to satisfy in order to get UI if they are on strike, and there's a waiting period, but it would be on the employer to ensure that there is tracking of who is and who is not out on a strike in case there is a need to provide unemployment insurance, which has a level of complexity here. If you can go on to the next slide, please. The last statute that I'm going to talk about specifically is the House Bill 1308, which was signed into law yesterday, and it will go into effect in July. This is some clarification on what the term personnel records means in Washington. So personnel records is now defined. Previously, it was not defined, and it led to some confusion. So now we know that it includes application records, performance evaluations, disciplinary records, and the other items listed there. If you go on to the next slide, please. It also gives requires employers to produce the personnel records to employees within 21 days of an employee's request. And there is a 5-day notice that employees must give employers before they bring a suit to enforce that requirement. But if the employer does not turn over the personnel records within the required time, then there's a progressive set of statutory damages that start to accrue based on how long it takes for the employer to turn over these records. As with other statutes under this section, this has a private right of action and allows for fee shifting. If you could please go to the next slide. So last and certainly not least, there are a handful of statutes that we wanted to alert you to that are new as of 2025. Some of these, I believe, have not been signed yet, so it's possible that the governor may veto them, although my information is a little out of date because I checked earlier this week. But some of these relate to collective bargaining for agricultural cannabis workers. That's a big change for that sector. The HB 1524 relates to providing isolated employees like night guards panic buttons. There are a couple which are at the bottom of this list relating to minor employment protections for minors and also violations for child labor violations and increasing the fines for those. So these are another 8 or so bills that you should be aware of that change the landscape for employers in Washington as of this year. If you could go to the next slide, please. I believe that this is the CLE code, and we have a little bit of extra time for questions, should anybody have questions that they want to ask. I'm not seeing any questions at this time, but if you have any for me, or I'll read the code in just a second. Somebody asked if they could get the code read out, but if you have any questions for me or the other presenters, please feel free to ask. The code is SS6429. And that should be on the screen here as well.